Hi, Tony DeWitt here, Missouri appellate attorney, retired, and somebody who likes to make the law make sense on YouTube. So if you're interested in an interesting discussion today, stay tuned.
Marriage. Marriage is what brings us together today.
It seems that whenever I do a video on the common law, one of the many questions that comes up is about common law marriage. And I've never done one on common law marriage, so I guess it's about time. Common law marriage has an interesting history. Before canon law replaced it, marriage was generally accomplished by cohabitation and a current intent to remain together. However, that model was broadly replaced in the Christian world when the Catholic Church declared in 1563 that marriages were not valid unless contracted in the presence of a priest and two witnesses. Even with this requirement, the Anglican Church recognized marriage by consent and cohabitation, and that was the law of England until the passage of Lord Hardwicke's Act in 1753. This act instituted certain requirements for marriage, including the performance of a religious ceremony observed by witnesses. The American colonies, however, rejected this requirement of a religious ceremony in large part due to the sparse population and the allowance of multiple forms of worship. But they retained the custom of ceremony, religious or otherwise. Marriage by agreement and cohabitation was adopted by the early American courts as valid under the common law. With westward expansion and the desire to civilize both the frontier and the people in it, the various state legislatures began in the 19th century to enact laws expressly to prohibit marriage without an observed ceremony and other requirements, most notably the marriage license. The majority of the states had, and currently have, these laws. Common law marriage was prohibited in a majority of jurisdictions, but the great laboratory of the states allowed for common law marriage in Alabama, Colorado, Georgia, Idaho, Iowa, Kansas, Montana, Ohio, Oklahoma, Pennsylvania, Rhode Island, South Carolina, Texas, and the District of Columbia. The full faith and credit clause of the Constitution, which is Article 4, Section 1 of the U.S. Constitution, requires that valid common law marriages established in any of those jurisdictions be treated as valid in states where common law marriage is not permitted. Google still tells you that Colorado, Iowa, Kansas, Montana, New Hampshire, Oklahoma, Rhode Island, South Carolina, Texas, Utah, and the District of Columbia all recognize common law marriage. That's partially correct. New Hampshire, as we'll see shortly, only recognizes it in one context, and South Carolina stopped recognizing the practice by judicial ruling in 2019. Now, there is an urban legend of a man, it's always a man, who was a common law spouse in one state and who frequently crossed the state line into the next state so that he could claim when he was having an affair that he wasn't legally married. Well, in that state, his marriage would not have been permitted. In other words, they wouldn't have recognized it. But in the state where he lived and spent most of his time, he was legally married because his state recognized common law marriage. But the fact is that nearly all jurisdictions in the United States are going to recognize a common law marriage that would be recognized in the state where it occurred. This is required, as I said, by the full faith and credit doctrine in the Constitution. If you entered into a common law marriage in Kansas, which has common law marriage, and you came into Missouri and you decided you didn't want to be married anymore, and you thought, well, there's no need to get a divorce, common law marriage isn't recognized here, you'd be wrong. Because if Kansas would recognize a common law marriage, then Missouri would apply Kansas law and require you to get divorced in Missouri if that is indeed what you decided you wanted to do. What you absolutely couldn't do is be common law married in Kansas, come to Missouri and say, hey, I'm not married, let's get married to your next spouse, and now, all of a sudden, you are a bigamist. So, anytime there is a valid common law marriage, there has to be a divorce to end that marriage. I don't want to encourage anyone to become common law spouse with anyone else. And it's not that I have some interest in protecting the state's monopoly on issuing marriage licenses. It's because I have seen the result of people having a common law marriage, and then something bad happens, and the question of whether they were married or not comes up in the context of inheritances and other places. Anguiano versus Larry's Electrical Service, which is a Kansas case, and as I mentioned, Kansas recognizes common law marriage, really helps make the case for formalizing a marriage with a license and a ceremony. In Anguiano, the question of common law marriage came up in a death benefits question under workers' compensation law. Anguiano was killed in an industrial accident while working for Larry's Electrical Service. He had been living with the same woman for 10 or 15 years, I forget exactly how many it was, and they generally held themselves out to be a married couple. But the administrative decision in the workers' compensation proceeding held that they didn't have a present marriage, a present intent to be married, and therefore they said the law would not recognize her as the spouse. However, when it went to appeal, the court recognized that there is some evidence that detracts from the board's factual finding. The court cited the evidence of witnesses testifying that the parties referred to themselves as husband and wife, and also that documents with the Social Security Administration indicated the parties lived together like husband and wife. However, the Kansas Supreme Court still affirmed the decision of the Workers' Compensation Board because substantial evidence supported the board's finding that the parties failed to establish a present marriage agreement. Now, Kansas doesn't require that it be a written agreement, but there has to be some evidence that there was an agreement between the two parties to be married. Now, you could establish that by testimony. You could establish it in a number of different ways, but when someone else is dead, when the party you are trying to assert is your spouse is no longer with us, there's no way to get his testimony, and a court has a right to disbelieve the testimony of only one person claiming to be a spouse because they want benefits. Thus, the workers' compensation insurer in that case was relieved of paying death benefits to someone who had lived with the decedent for a very long time, had held herself out as his spouse, he had held her out as his spouse, but because there was no evidence that the two ever actually decided to get married, the case essentially failed on that note. This often happens when a person dies without a will and without evidence of a marital agreement, because a lot of times there are children, sometimes children from prior marriages, sometimes there are direct lineal descendants like brothers and sisters who might want to claim a share of someone's inheritance. There are all manner of reasons why, if you formalize an agreement with a marriage license, you ensure that you have access to the benefits that come from being married. And of course, one of the benefits that comes from being married is the ability of your spouse to refuse to testify against you. So there are stories like this in nearly every state of the union, but here's another one from Kansas. It's a criminal case, and a man tried to keep his asserted common law wife from testifying against him in a criminal trial on the basis of this marital privilege. The court allowed her to testify, saying here, Miss Williams testified that she never signed her name as Mrs. Earl Johnson. The parties held themselves out as husband and wife only to the defendant's employer and their landlady. As to the public in general, there was some substantial question as to whether the relationship between the parties was man and wife. Moreover, when the appellant was questioned by a Wichita police officer, he stated he had registered under a fictitious name because he was staying there with his girlfriend, whom he identified as Joanne Williams. It thus appears that Joanne Williams and the appellant held themselves out to be man and wife only when it was advantageous to assume a marriage posture. Lacking the requirement of a holding out to each other as husband and wife and to the public, there was no common law marriage, and the claim of marital privilege is without merit. As you can see, there are problems if common law marriage is not created with nearly the same amount of formality as a church or courthouse wedding. And if you've lived together for several years and referred to yourself as a spouse, and now you think you have it made and can go get a divorce and claim half the property, you might want to rethink that. Because if your spouse says, I never agreed to be married, we just lived together. Sure, we called each other man and wife, but we just did that to fit in. I never wanted to be married to her. Well, now you've got a problem. There's going to be a good chance you're going to have a hard time proving that a common law marriage existed, especially if you have moved from a common law marital jurisdiction. So, I want to go through briefly the requirements in the jurisdictions that still recognize common law marriage, and I want you to keep in mind this is only current as of September 24th. It's a statement of information that is readily available on the internet. It is not intended as legal advice. And you would be well advised to check closely with any local attorneys in your jurisdiction if you have a question about any of this. So here we go. You're going to find that a lot of these requirements are the same all over the country. But in Kansas specifically, to prove the existence of a common law marriage, the parties must meet 3 requirements. They must prove that they both had the capacity to marry. They must prove and they must demonstrate that they both intended to be married. And they must have both held themselves out to the public as man and wife or asserted that they were a married couple. And as I've said previously, when these have been challenged by other people who might want to claim inheritances or for other reasons, normally that's a situation where they lack the ability to prove the intent or the agreement to be married or the holding out. Those are the 2 things that usually cause a great deal of problem. And here are the common law marriage requirements in Colorado. You have to cohabitate, you have to live together, you have to hold yourself out as a married couple. In other words, Nancy Jones starts calling herself Mrs. Nancy Smith. You file joint tax returns, that sort of thing. The couple has to show that they both had legal capacity to marry. So they have to be of legal age, not related, not first cousins, not be married to somebody else. And both must agree to be married. So again, there's this intention to be married requirement. And again, the requirements are very much the same in Iowa. A present intent on both parties to be freely given to become married. A public declaration by the parties or a holding out to the public that they are husband and wife. Continuous cohabitation together as husband and wife. This means consummation of the marriage. And both parties must be capable of entering into the relationship. In other words, no first cousins and no bigamy. Montana, consent and agreement. The man and woman must mutually consent and agree to enter into the marriage contract, be legally competent to enter into the marriage, and cohabit and hold themselves out as married. Again, very similar to these other jurisdictions. When we get to New Hampshire, though, things change just a little bit. Common law marriage is only recognized in New Hampshire for inheritance purposes. So, if you go to get health insurance on the basis of your spouse, you have to have a marriage license to prove that you are a spouse. You can't do it on the basis of common law marriage. And for inheritance purposes, you have to show that the couple lived together for more than 3 years preceding the death of the other spouse. The spouses had publicly acknowledged one another as husband and wife by their actions, like filing joint tax returns, using the same last name, that sort of thing. And the couple was generally known as husband and wife in the community. Then you can claim for inheritance purposes, but if you want to get state benefits or if you want to get the benefits that come from, for example, filing state tax returns as a married couple, well, then you have to have the marriage license and formalities associated with a regular marriage. In Oklahoma, again, it's just actual and mutual agreement to be spouses, permanent and exclusive relationships, cohabitation as spouses, holding out as spouses to the community. Oklahoma has an affidavit to attest to common law marriage available. Now, this is through the teacher's retirement system of Oklahoma, but this is essentially a situation where you could use this affidavit in Oklahoma to fulfill the requirements of common law marriage. And here's the affidavit. The undersigned hereby declares that the following elements have been met, constituting a common law marriage in the state of Oklahoma. We have an actual and mutual agreement to be spouses. We are in a permanent and exclusive relationship. We are currently cohabitating as spouses. And 4, we have presented ourselves to the community as a married couple. So both spouses sign with their birth dates, and the member of the teacher's retirement system gives the last 4 of their social security number, shows the date that it's executed, and it's executed in front of a notary public with the notary seal, and you have now satisfied the requirements of common law marriage in Oklahoma. In Rhode Island, the common law marriage requirements are that people must show a serious intent to have a spousal relationship. Neither party may be married to another person, and the couple's actions must demonstrate to the community that they're married. Again, very similar to most of the other jurisdictions. Common law marriage in the great state of Texas. Texas law states that a common law marriage can be proved by evidence that the couple agreed to be married, and after the agreement they lived together in the state as husband and wife, and they represented to others that they were married. Very much like other states in this regard. Texas, on its webpage for this particular issue, notes that same-sex common law marriages are also recognized in Texas, as they would have to be anywhere else that there was a common law marriage doctrine, because, again, full faith and credit and the Obergefell decision by the Supreme Court. In Utah courts recognize a marriage to a petitioner should show an agreement between the partners of legal age and capable of giving consent, legally capable of entering a solemnized marriage, in other words, no first cousins, no bigamists. They have to cohabitate. The couple has treated each other as though they were married, and they present themselves to the public. Again, pretty much all the same elements, just stated differently, and that happens a lot in the difference between the laws of the different states. You often have the very same requirements, they just state them in different words. And the District of Columbia also recognizes common law marriage with intention to be married, legal ability to be married, and holding out as a married couple. Again, no big surprises there. That, in a nutshell, is common law marriage. And it's an interesting topic, and it certainly is one of those things that comes up from time to time. Again, if you are in a common law marriage at this point, and you are, in your 50s or 60s, you really need to think about going and getting an actual marriage ceremony, because at the time of death, when this kind of thing comes up, you need to be able to prove that you are a married couple. And if you are not listed on the death certificate, if you don't have a marriage license to demonstrate that you are married, it makes it a lot harder, and it just doesn't need to be that hard. Marriage licenses don't cost that much, and if you've been together for 20 or 30 years, nobody should have an issue with being married at that point.
Man and wife. Say man and wife.
Man and wife.
At that point. So that's what I have for you today. If you have any questions, drop them in the comments down below. Like, share, subscribe, all those good things. And, of course, if you have the opportunity today, go out of your way. Do something nice for somebody. So after you've done a kindness, if you would, come on back tomorrow. Join me down here at the beach, and we'll talk about something else, and we'll have a little more fun. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. So please don't take anything I say here as legal advice, and if you need legal advice, see a lawyer in your jurisdiction. And here are some videos that YouTube thinks you may enjoy.